Hi there, this is Erica Marilyn. I'm the founder of Perfect Legal Video, and I am very excited to have with us today Attorney Jim Sorenson. He has the Sorenson Van Leuven law firm out of Tallahassee, Florida, and they work in Georgia and in Florida with credit unions. Thank you so much for joining us today, Jim. Welcome.
Thank you for having me, Erica. I'm excited to be here today.
Yes, and today we are going to be talking about something very interesting and I think very near and dear to a lot of our hearts, and it is the Servicemembers Civil Relief Act, also known as the SCRA. And we're going to be talking about handling reductions. So we do talk about a lot of different parts of the law, and where this is concerned, could you give us a brief overview of the act and bring us up to speed on what's happening with it?
Yes. So the Servicemembers Civil Relief Act, known as you indicated as the SCRA, is a federal statute, and it is a statute that originated back during World War II. It has obviously evolved over the years and changed. The last major rewrite was when President Bush in the 2000s after 9/11, where we had service members being deployed again. And the law is aimed at protecting our active military personnel. And the law provides certain protections regarding civil matters. So this is purely involving civil aspects of the law. The law has protections for service members and their spouses, and those protections include interest rate reductions on certain loans, limitations on when and how you can repossess a vehicle or other collateral, limitations on evictions and foreclosures, protections in legal actions, civil legal actions against individuals who are active military, where their military service may negatively impact their ability to defend a lawsuit or participate in a lawsuit. So, that is a brief overview of the law. The law is enforced by the U.S. Justice Department. We have seen over the last several years certain actions by the U.S. Department of Justice against creditors or lenders who violate the law. They have the power to bring criminal action and/or civil action to punish behavior that is not in line with the law. And it's one of those laws that we at our law firm get a lot of questions on from our clients.
I'm sure you do. I mean, because who doesn't want to do right by our military? We want to make sure that they are protected. So how does the protection of the interest rates work?
Yeah, so the law provides an interest rate cap of 6%. And the interest rate cap is simply that the rate of interest charged on a loan cannot exceed 6%. So if a service member has a loan where the interest rate is 10% and they're entitled to this interest rate cap, then their interest rate would be reduced to 6%. The service member takes advantage of the interest rate cap by providing the lender, its creditor, with a copy of the military orders or other official paperwork that evidences their active military status and simply requesting the rate reduction. So that is how they are to go about it. The interest rate cap only applies to those service members who are active duty. So if you have a person who is a reservist or in the National Guard, but they're not on active duty, this would not apply. But anybody who is in the U.S. Army, in the Marines, in the Navy, Air Force, etc., active duty, this would apply.
Well, that makes a lot of sense. Now, I know that the credit unions you work with actually have a lot of different types of loans that they provide their clientele. And I just wondered which types of loans apply for this type of an interest rate cap.
Yeah, so it really applies to any loan. The determination of which loans it applies to is not necessarily the category of loans, but when the loan originated. So if a person is active duty and they get a loan, they are not entitled to the interest rate cap. But if they got the loan prior to being active duty, they are entitled to the interest rate cap. The idea behind that is that if you have a civilian who is, and you have to think back to how it worked or would have worked during World War II or any other foreign war, that really is the catalyst for this law, is that you would have a, what has been termed by many historians, civilian soldiers. We have people who are reservists, National Guard, or who are just civilians. A war breaks out and they join the military. And their military pay is maybe, in a lot of cases, less than their civilian pay. So one of the protections that was put in place was to cap the interest rate at 6%. But again, it only protects those loans taken out prior to active military service. So if someone is in the military, like my son who is in the Army, if he were to take out a loan right now, it's whatever the going interest rate is between that the bank or credit union charges. And so that is the distinction. Was the loan, or did the loan originate prior to active military service or not?
So there's no cap on the rate for somebody that is actually in the military right now getting a new loan.
Not under this law. There are some other laws that apply to there's the Military Lending Act, which is a whole nother law that has protections for people who are getting loans while they are active duty. That is not the scope of this law. And of course, there are state laws that have limits on interest that would apply as well. But the 6% interest rate cap in the SCRA is limited only to those loans that were incurred prior to active duty, that and the borrower debtor is now active duty.
Wow, that's really interesting. So, can you tell us? I know you mentioned before that the individual has to provide their orders. Now, how long do they have to make the request? Do they have to make the request themselves, first of all? And then, is there a time limit on making that request?
Yeah, as a general rule, the request, has to come from them. I mean, there are exceptions where their spouse can be involved or maybe someone with the power of attorney. But as a general rule, the request comes from them, from the individual service member. And again, they've got to provide their orders or some other satisfactory paperwork that evidences their active military status, and shows their start date. And the the timing of that request is interesting under the law, because the timing is they can make the request anytime during the time period they are active duty, but the request must be made no later than 180 days after their active duty status terminates. So in other words, if a person obtains a loan, then they enlist in the Army and they serve their 4 years and get out of the Army, they would have 6 months, 180 days, roughly 6 months from the time their active duty status with the Army ends in order to make the request. So the request can actually be made retroactively on the back end of their active military service. Somewhat unique in this law because that's not how most laws work. The window is very broad.
What ha- what happens to the interest rate if they request a rate cap? And is interest deferred or forgiven?
Yeah, so under the law, the way this works is the interest is to be forgiven. Sometimes there's some confusion on this. They think the thought process is that interest gets deferred till some point in the future. And that isn't the case. The interest is forgiven. So again, if we use the example, the loan was originally at 10% interest. it gets reduced to 6%. There's a 4% reduction in the interest rate. And that 4% reduction in the interest rate, that interest gets forgiven. And again, it's reduced for the time they're active duty. So depending upon how long their term of active duty is, how long the loan is, the interest rate reduction may be for a portion of the loan, or it may be for the whole life of the loan. It will depend on, again, length of service and length of the loan. So if, as I indicated earlier, the active service member can request, or the borrower can request, that the interest be forgiven or the interest cap be applied retroactively. So the loan could have paid out a year ago, but they're still active duty, and they now realize, hey, I was paying 8% on that loan, I want the 6%. If they request it, the creditor must not only give the interest rate cap, but they have to refund the interest paid, and that's a cash refund. They can't apply it to any remaining loan balance or any other loan balance. The service member would get all that interest back.
Wow. So that's the kind of gotcha that if a credit union was not keeping track of and informing a service member that they could have this cap, it could kind of bite them later on if a whole bunch of service members found out about it and requested a lot of refunds.
Yeah, I mean, what happens a lot of times is they don't, a lot of times the credit union isn't aware they're a service member. Sometimes they are, but not all the time. But what happens is I will get the call, hey, we've got a member who was in the active military service. They are no longer, but now they're requesting us to go back and retroactively apply this interest rate cap. Do we have to? And so again, the starting point is always, when did they get the loan? They got it before they were active military. How long were they active military? They were active military for 4 of the 5 years of the loan. And when did they make the request? Was it timely? Well, their military service ended on this date. They made the request 4 months later. Okay, so the request is timely. It applies to the loan. You have to refund 4 years of the interest difference between 6 and whatever the contractual rate is. And again, this is going to depend on the type of loan and the credit quality of the borrower. Right now, interest rates are really low. So if you have good credit and you borrow on an auto loan, chances are your interest rate's lower than 6%. Mortgage loans are lower than 6%, unless you have really bad credit or it's a unique product. But credit cards, unsecured loans still typically are going to be above 6%. So the impact to lenders does depend in part on the type of loan product it is, what the borrower's credit risk is. All those things come into play.
Wow, that is really interesting and a bummer for the bank. But obviously, we still want to take care of the servicemen. So, servicemen and women out there. So, does this law impact other fees or charges on the loan, such as late fees?
Yes, it does. And this is another area where I think there's confusion. Under the SCRA, the term interest has a unique definition that is different from most other laws. In most cases, late fees would not be considered interest. But under the SCRA, the definition of interest includes, and I'm quoting now, service charges, renewal charges, fees, or any other charges. So that determination that charges and fees come into play makes it appear as if late fees would be calculated in that. And that appears to be the correct interpretation. The exception of charges on a loan that aren't considered interest under the SCRA is charges for bona fide insurance. So there are times where, for example, in an auto loan, if the borrower doesn't maintain insurance on his or her car that is under lien to the credit union can go and purchase insurance for that loan, for that car, and charge that interest or that insurance, excuse me, to the loan. The SCRA specifically says bona fide insurance charges are not interest, but any other charge or fee is or probably is considered interest. So as such, what we tell our clients is if you cap the interest at 6%, you do not charge any other fees on the loan. If you're charging the interest lower than 6%, then of course the fees could come into play. So if the loan is a 4% loan and your fees aren't going to take it over the 6%, you're fine charging the late fee.
Oh, that's good to know. And thank you for clearing that up. I can see where some of this would be very confusing. So can you tell us what happens to the payment then once they have made the change to the rates?
Yeah. So again, this is another area of the law that I think sometimes people misunderstand or misapply. And what the law provides is that the monthly payment must be reduced proportionately to the interest rate reduction. So if you think about it, I'm using monthly payment here, but it's whatever the periodic payment is. Loans are typically monthly payments, but there are loans that are biweekly payments or weekly payments or semi-monthly. Whatever the periodic payment is for the loan, that loan payment should be reduced to an amount based upon the reduction in the interest rate. So if you think about it, every periodic payment has a portion of it that goes to interest and a portion that goes to pay the principal to retire the debt. And so that portion that's going to interest, if it goes from 10 to 6%, that portion going to interest would be reduced by 40%. And so that results in a lower periodic payment moving forward or during the time the rate cap is in place.
What are some of the ways that your clients might struggle when trying to comply with this law?
Yeah, so I think we went over some of them. Some of the struggles come from just maybe a lack of understanding, a lack of some of the technical aspects of the law, as we talked about the payment reductions, the late fees, and how those play into the interest rate calculation. The other struggle that comes into play is more of a practical struggle, and it comes up with open-end credit. So when I use the term open-end credit, a lot of people in the credit union world or lending world will know what I mean by that. But just for clarification's sake, open-end credit is the type of loan that assumes there's going to be multiple advances. This is usually where you have a line of credit. So the typical example would be a credit card, but it could be a HELOC, it could be some other unsecured line of credit product. And so take the credit card, for example. If they obtain the credit card while they are not active duty and then later become active duty, the interest rate cap would apply to any advances taken out prior to active duty, but would not apply to any advances after their active duty. So again, think of a credit card. They got a credit card a year before going active duty. They used it, they made charges, they didn't pay it off in full. So at the time they file back, the time they go into active military service, they have $1,000 on their credit card. That's the balance. And then they're active duty and they continue to use it and they incur another $700, let's say. The original $1,000 would be capped at 6%. But the new $700 they incurred after going active duty would be at the contractual rate of interest. And so this creates this, you're not applying the interest rate reduction across the board. You have two balances. And this gets into how your software system handles it, how you handle the payments coming in, what payments go to what amount. It can get real complicated. And sometimes it causes confusion as to how to handle that. And sometimes the service member, the soldier, the sailor, the airman, airwoman, whoever they are, they don't understand that. They think because they got the credit card a year before they joined the Air Force, now it should cap 6% on everything, including the charges incurred after they went active. And it doesn't work that way on an open-end loan. So it is different than an auto loan where there's one advance to finance the auto, and now you're paying it steadily off over a set term. So that is one complication in the law that sometimes is a gotcha. And it's just something that credit unions, creditors have to work through.
That is very interesting. So, are there laws such as this on the state level, and how does it differ if there are?
Yeah, there are laws on the state level. Florida actually has a law that is has some certain aspects that are of protections that apply, but Florida does not have an interest rate cap in its law. But one state that does, and I think there's others, but one example is Ohio. Ohio has a statute that provides an interest rate cap. Again, it's a 6% cap, just like the federal statute. The difference is the Ohio statute applies to loans based on retail installment contracts. Retail installment contracts are the contracts that are used to purchase like an automobile at the dealership. So if the lender makes those loans on retail installment contracts, the Ohio law comes into play. The other aspect of the Ohio law is it doesn't matter when the loan was incurred. So even if the person was active duty when the loan occurred, the 6% interest applies. So Ohio's gone a step further and given further protection to active military members or people in Ohio who reside in Ohio. And that law expands SCRA protections. And sometimes this can be confusing because it's not always clear when does the Ohio law apply. The loan originates in Florida. The member lived in Florida when they got the loan. They now live in Ohio, and maybe they're stationed in Ohio or they've moved there upon leaving the military, and they want to apply the Ohio law to the loan at question. And so it's no longer a question of did the loan incur prior or after military. It simply does the Ohio statute apply to this loan.
Yeah, I think that's very, very interesting. So I know that having a law firm such as yours is going to be incredibly helpful in some of these situations. Is there any information as a lawyer in this area that you can give your clients, or even people that aren't your clients, even credit unions that aren't your clients, on how they can best comply with this particular act?
Yeah, so I think the key in compliance is, with this act is having in place a well-developed procedure that's consistent with the law. I'm sure, Erica, you and I have done several interviews. You've heard me say this before: procedures, procedures, procedures. I really think that the starting point of trying to comply with the law is having well-drafted procedures. It has to be a place that the credit union employee can go and find the answer, right? And not make assumptions. Well, I assumed the late fees weren't part of interest rate. That, what does the procedure say? That's the starting point. Second, training. Some credit unions have a large number of members who are active military, and their employees deal with this day in and day out. Some of the credit unions are actually credit unions that revolve around active military members. The majority of their members are in the military. They understand this law. They deal with it day in and day out, and the confusion doesn't really typically come from those clients. It comes more from my clients who do not have a large active military presence in their membership. Their customers generally aren't active military, so they deal with this a couple times a year. And the only way to make sure that the employees of that credit union understand what to do is training them that this is an issue, training them that, hey, we have a procedure, training them on who's the person to handle this, right? So when the interest rate reduction request comes in, when there's a request to cap it at 6%, and those orders come in from private John Doe, where in the credit union does that go so it's handled properly? That takes not only having the right procedures in place, but training on top of that. And that training has to happen often to keep it fresh in everyone's mind. And then finally is a review of the credit union's practices to be sure that the law is being followed. So, you have to inspect what you expect. You can't just expect that your employees are doing it. You can't expect that this department's handling it right. You actually have to inspect that. And again, I'm probably a broken record here, but these are the three things that I think are key in so many situations. And yet so many times these follow throughs are not done. And, we partner with our clients to help them with this. We can help them develop a well-drafted policy or procedure that will guide their staff. We can provide training or help develop training for their staff. And then finally, we can help them with a review. Whether we're helping them develop the right way to conduct the review and they can do it internally, or they hire us to do the review. Either way, we can help. And so, I just challenge people listening to the video to give us a call and let us help them make sure that their credit union's complying with this law.
And I know that your clients really appreciate that. I mean, there's just so many moving parts. It's almost impossible, I would say, to really conduct business the right way and comply with all of these laws and rules and acts without having somebody that knows what should be on the checklist every time and what has changed. Even more importantly, to help make sure that your clients and other credit unions don't actually get all of these class action lawsuits and fees and just headaches to have to go to court and try to constantly fight over mistakes that they made, when an ounce of prevention is worth a pound of cure, and you're the ounce of prevention, that is for sure.
And if I could say just one more point to that, I think you're right. A lot of these regulations and laws can be complicated, and compliance can be a hard thing. I think in a lot of cases, the SCRA is the most dangerous, not necessarily from what you may face in a lawsuit, but what you face in reputational risk. Because, if it gets out in the news that ABC Credit Union doesn't follow the law to protect active military members, that is just not something that the general public takes kindly to. It looks bad. It always looks bad when you have a regulated industry, a regulated business not complying with the law. But there are certain parts of the law that the public interest peaks at, right? You're not protecting military. Is one of those that's pretty high up. So to me, this is one of those higher risk areas of the law from a reputational risk. And so, the key is let's take all the steps necessary to do it right and not end up being featured in a news article where ABC Credit Union is the bad guy.
Absolutely. And, I really appreciate you coming on here, letting us know what we need to look out for now, because, the world is an ever changing place, especially right now. And, definitely want to make sure we keep up with this. So thank you so much for coming on again today and giving us all of these examples and information. And I would absolutely recommend to anybody out there, any of the credit unions that are watching, if you feel like you need help, Sorenson Van Leuven Law Firm will treat you like family, and they are up on everything new that is happening in the law as it pertains to credit unions. And they can save you a lot of money just by showing you how you could avoid getting fees and going to court and class action lawsuits and the rest of it. So thank you so much again. We really appreciate your coming on.
Thank you, Erica, for having me.
All right, we'll see you next time.